We are really fortunate to have with us today Professor Shubha Ghosh. I think most of the people who are sitting in this room knows Professor Ghosh because some of you have taken his course, some of you might have already read his works. For those who doesn't know him, he is the Grantal Melvin Professor of Law and Director of Technology Commercialization Law Program at Syracuse University. He's also a Fulbright visiting faculty at NLU, so he has been staying here for the whole semester. But most importantly, he is one of the most eminent scholars who works extensively in the areas of intellectual property as well as competition law. So on behalf of the center as well as NLU Delhi, I would like to say a warm welcome to Professor Ghosh. I would also like to specifically welcome Professor Dr. Sumita Ghosh, Professor Shubha Ghosh's wife, for joining us today evening. I think she arrived only back. I'm so glad that you joined for this session. I'd also like to warmly welcome our colleagues, in particular Professor Rustam Ghosh and also research staff from all the other centers. And most importantly, I'd also like to welcome all our students for joining this session. So welcome you all, and Professor Ghosh.
Thank you so much, Arul, for Saskaria. And I'd like to warmly thank the National Law University and the Center for organizing this lecture and for being such wonderful hosts the last few months. I visited the law school a number of times now, and I've always enjoyed coming here and enjoyed the environment and the atmosphere. And I learned as much as I hope people learn from whatever little I have to say. So, and I also want to thank you for taking the time to come and meet with me during this very busy end of the semester. So hopefully we'll have some interesting discussion about, I think, some very interesting issues that are pertinent not only here in India, but also throughout the global marketplace. And this has to do with issues of free speech and free markets. And specifically, I want to deal with these two issues from the perspective of intellectual property, which is one of my major areas of research and writing, because I think within intellectual property, specifically the areas of trademark, copyright, and patents, you see some very important intersections between the notion of speech and the role of markets. And before I go into some of the details, it might be useful to talk a bit more broadly about why I'm interested in this topic, and what brings me to intellectual property, and also what brings me to the Fulbright and the research that I've been doing here. And very broadly, I mean, I'm always hesitant about these sort of broad statements. This talk is motivated by the concern about the relationship between democracy and capitalism, very broadly. I'm not going to resolve that relationship in any ways. In fact, I'd like to spend some time taking that apart and trying to understand. And I think that relationship between those two sets of institutions, or those two sets of ideologies or viewpoints, normative structures, however you want to call them, are very important for understanding economic development and the role of law. And I think intellectual property can be understood more deeply by really looking at those sets of relationships. So nobody knows, whenever you speak, what people will get from what you say. I think most people just want to sustain the hour if they can. But hopefully you'll get some sense of the broader themes as well as some of the specific disputes and debates that are happening, I think, in many countries that I want to give you a sense of. So some of the principles and concepts of free speech people talked about as a particularly U.S. concept. We have the First Amendment of the U.S. Constitution that talks about freedom of speech and freedom of religion and other things. And I'll talk a little bit about that context. But I want to talk about these principles more broadly, especially as they relate to the notion of free markets, market liberalization, whatever the notion of the economic sphere is. And if you think about some of the big debates, especially after World War II, one of the big debates, and this has guided the foreign policy of many countries, is that in order to have some sort of development, there has to be some sort of an authoritarian, either political structure or even an economic structure. The authoritarian economic structure might be some type of centralized planning. But even if you don't have centralized planning and you rely more on decentralization, there's still an argument to be had for, often made, for at least authoritarian politics or some limits on democracy. And the idea is that too much democracy can upset economic development. And so this is a notion that guides, I think, a lot of policies if you look at in the 60s and 70s and even into the 80s. But now as we look at our history post-Cold War, and as you see the emergence of a lot of formerly less developed countries, I read somewhere, I don't have the citation, that the World Bank doesn't like the phrase least developed anymore, which is probably a good idea. Maybe it doesn't have the same meaning that we'd like to have. But we need to rethink about the relationship between economics and politics and the relationship between democracy and capitalism. I mean, within the notion of sort of an authoritarian model of democracy, and I just want to be very careful here that I'm not going to, as I speak in these terms, you may be thinking about particular countries, but I'm going to be very careful and not name any countries by name. Okay, but you can think about this as a relatively mid-level of abstraction for what I'm talking about. But then, if you want to name any countries in the Q&A period, feel free to do so, and I'll try to respond accordingly. But the idea behind some sort of authoritarian notion of development or authoritarian-led democracy, authoritarian notion of led development, is that once you have the development of free markets, and then once the free markets sort of create different types of mentalities, different types of culture, then democracy will flourish at the end. So that's sort of the full picture. But the reality often is that authoritarianism doesn't necessarily yield that quickly. And the reality is also that authoritarianism doesn't necessarily lead to the kind of economic development that might be most desirable. It might be desirable in terms of certain types of metrics, but it may not be desirable in terms of notions of human capacity, human flourishing, and other things that contribute to development that are captured a little bit in the notion of free speech. And so what I wanted to leave with today is sort of challenging that notion and thinking a bit more about the relationship between free speech and free market as a way to think about the relationship between democracy and capitalism and the way in which intellectual property law intervenes in that set of relationships. And so when you think about free speech, there are lots of ways in which free speech gets translated or gets implemented. I could have used the notion of freedom of expression. I think freedom of expression may be a little bit more expressive, so to speak, or a little bit more revealing than the idea of free speech. Free speech suggests that you can just say whatever you want, whenever you want, and so forth. And it has some focus largely on verbal acts, while freedom of expression talks more about the whole identity, the whole notion of how one presents oneself and so forth. And some of this comes up in the recent ruling regarding transgendered population and the right of expression, and that comes up there within India. But one of the things that connects free speech and free markets, other than the notion of free, and for those who may have read, for example, Lawrence Lessig work, knows that the word free has lots of different meanings, and some of which I'll play with here. For those who've not heard the joke, we often talk about the word freedom in the context of law to mean the same thing as freedom of speech rather than free beer or free food, right? So we don't mean that it necessarily comes at zero costs. In fact, people might exercise these rights with extreme costs, sometimes even involving giving up their life or giving up jail time, things like that, right? That type of freedom of movement. And so I'm going to focus a little bit, when you think about free speech, free markets, in these metaphors of marketplace. So we often think about the free markets as marketplace for goods or services. And free speech, at least going back to Oliver Wendell Holmes, we think about the marketplace of ideas. And the metaphor of marketplace is very troubling in many ways because it suggests some notion of unregulated, laissez-faire, anarchic, whatever the metaphor might be. But I view the marketplace, and hopefully you'll get a sense from my talk, as something that is constructed. It's an institution that has rules. It's not just simply unfettered freedom in some ways, though of course it does have some connection to human notions of freedom that are very important. But you have to also understand the notions of ways in which a marketplace is constructed, whether you think about the marketplace of ideas or the marketplace for goods and services. And the problem with marketplace also is that it suggests something that's quantitative, that something is price-driven, something that is based upon those types of metrics. So you have economic theories of markets, you have notions of the auctioneer, and so forth. And those are all very interesting metaphors. They get played with in many contexts, both in the social science literature, but also in the movies. So if people watch, for example, the famous Alfred Hitchcock movie North by Northwest, there's wonderful scenes in those movies. I recommend that movie. I think it's available on Netflix and other media. But there's a wonderful scene involving an auction where somebody is, typical good guy, bad guy situation, and the good guy is trying to get away from the bad guys in an auction. And the way he does that is keep bidding up the price, so people are sort of wondering what's happening, and he creates some sort of anarchy and disorder. No, it's okay, in the auction setting, and he's able to escape very quickly. And this is sort of the notion that we think about with the marketplace of ideas. It's not so much about some sort of an exchange of a material good for money or a material good for other material goods. We're thinking about a verbal exchange. And notice the way we use the word exchange in so many different ways in law. Obviously, we talk about financial exchanges, we talk about commercial transactions as a type of exchange, but we also use the same word to talk about just a conversation or some other type of interaction. Even if you think about the idea of advocacy, an advocate is exchanging thoughts, exchanging arguments with the judge. So it's interesting to think about that notion of exchange more broadly. And even when you're thinking about the more traditional type of exchange in a commercial context, there's always some sort of a cultural dimension to that. That something is being communicated when you're buying something. Let's say you're going out shopping for a wedding, or you're going out shopping for... It's not just simply kind of a material need that is being satisfied. It is in this broader context. And so I think it's important to think about the phrases free speech, free markets, marketplace of ideas, marketplace for goods or services, in some ways metaphorically. And I don't mean metaphor, the metaphorical use as a sacrifice for analysis. I think sometimes when people hear the notion of metaphor, they say, oh, you're giving up on sort of analytical ways of thinking about these problems. But we can take that metaphor and really see how it gets used in lots of different ways. And so I interrupt at this point of my talk with a confession that I really stole this idea from somebody else, or at least the idea for this talk from somebody else. And the lawyer and economist Ronald Ghosh, if you're going to steal, you should steal from the best, right? So I think he probably qualifies as being the best. Wrote an article in 1970 called The Marketplace of Ideas and the Marketplace of Goods. And it was just a very short article, and Ghosh people may be familiar with as thinking about how legal rules and entitlements are redistributed through private ordering and private negotiation, and how disputes are settled in that particular way. A very rich social scientific view of the law. But in that particular article, he makes some interesting points, but he also makes some false comparisons. Because that particular article, he asked the question, and remember this is the context of 1970, and he asked the question why more leftist, left-leaning members of the legal academy or the academy in general, they want an unregulated laissez-faire market for speech. And that was the situation in 1970, that most of the proponents of free speech were on the left in the US, and probably in Europe as well, while the same leftist thinkers were wanting very strong regulation for the marketplace of goods. And he asked the question, does that make any sense? In some ways, ideas are just another type of commodity. At the same time, you can think about commodities as just simply instantiating different types of ideas. That's certainly the case when you think about copyright, as movies and books really instantiate ideas. So why is there that tension? Is this consistent or not? And I think, as much as I admire Ronald Ghosh, and that's a very interesting article, even though I did steal the idea for this talk from that article, I differ from it, because I think he makes a very false comparison. And because that article was written in 1970, if you fast forward 40 years, at least in the US landscape, you get quite a bit of change. I mean, you have a lot of people on the left talking about markets as being maybe a force for democracy. That the markets have this aspect of freedom. This is certainly, again, country-specific and culture-specific. But if you look at those individuals who are the strongest proponents of free speech now, they tend to be conservatives. So it's the people on the left that are concerned about hate speech on campus, for example, or people on the left who are worried about trigger warnings. These are types of things. So, Ghosh's article in 1970, is very specific, maybe to his own curmudgeonly views about left and right and to the specific context of 1970. But this notion of where freedom should rest does change and can become very contextual. And so this gets to the broader point behind this, and will be an interesting bridge to think about intellectual property. Is this just simply hopeless, that we sort of have freedom changing depending upon what the whims and winds of politics might be? So in 1970 it meant one thing, and 2016 it means something else. I think the way to sort of unpack this is that largely we're talking about the ways in which information flows and knowledge is constructed. And if you think about some of the differences between the 1970s, and I was just, I was barely out of diapers in 1970, so I'm not one to speak knowledgeable of the 1970s, a little bit past diapers in 1970, but nonetheless, I'm now closer to diapers on the other end in 2016, I guess. But nonetheless, I can talk a little bit about changing political winds and context. But I think the ways in which we think about knowledge, the ways we think about information, has really affected, how we think about this freedom. So, for example, the way we understand universities have changed quite a bit. In the 1970s, there's really kind of a view of the university, at least in the U.S. and I think in other countries, certainly in Europe and Latin America, as sort of a sanctuary. It was a sanctuary against political repression. It was a way in which you could voice opposition to the government. Universities now in 2016 tend to be more corporate. They tend to have a lot different type of atmosphere in the way in which knowledge, and therefore it may not be completely surprising that the political notion of freedom, at least freedom of speech, has changed given that institutional change. So it's useful then to unpack these notions of freedom of speech and marketplace of ideas, to think about how information flows in society, and specifically the ways in which information flows to produce different systems of knowledge, right? Whether that system of knowledge might be in economics or in politics or religion, or it might be in law, right? And those are kind of the ultimate kind of issues that I'm trying to get at in this particular talk. And so if you think about the ideas behind Ghosh, I mean, Ghosh's point is why do leftists want regulation of the marketplace of goods, but want to leave laissez-faire in the marketplace of ideas? The point that he misses is that there's always some regulatory structure in any of these markets. And so when the left, so to speak, talks about freedom of speech with respect to the marketplace of ideas, they really are concerned about an environment in which the government controls particular viewpoints, the government controls the way in which university students, at least think about the context of 1970s, might get drafted to go to war, the way in which resources are used within the university to support military-type research, and therefore they're thinking about a very different regulatory structure than when they're thinking about the marketplace for goods and services, where the regulation is there to protect consumers. The regulation is there because consumers may not have full information or knowledge about the products or services they're buying or engaging with, and therefore we need a different set of structure for that. It's just simply a false comparison to say that it's contradictory, to say freedom in one implies freedom on the other. You really have to think about the broader sort of context in which this occurs. So, with that background in mind, and also keeping in mind that I'm not going to keep you, past 6 o'clock, and I want to have some time for discussion, I really want to kind of focus on now two things that are a little bit more detail-oriented, right? And the first is about legal landscape, and understanding a little bit about the legal structure for freedom of speech and freedom of markets and how they intersect. And then I'll move on to how that legal structure plays itself out in some very interesting debates in intellectual property. So I realize audiences come for different reasons, sometimes just to learn. Some people may have come for just the intellectual property part, some people may have come, so I'll try to give some little previews. If people are not interested in freedom of speech and the law behind that, I'll let you know that when I get to intellectual property, I'll talk about 3 areas. One area is this issue within trademark law for disparaging trademarks or scandalous trademarks. And then I'll talk about copyright and fair use and how that works in terms of this notion of free speech and free markets. And then I'll talk about this notion of standard setting that is coming up in competition law and the intersection between competition law and patent law. And these themes are 3 disparate areas, but the point of putting these 3 disparate areas is to show how they deal with communication. So the trademark area, the idea is that the trademarks are in some ways a form of expression, but what do you do when that expression might be hurtful, especially when you're dealing with trademarks that are brought on commodities, right, marketable commodities. That's why trademarks are so interesting, is because they're both speech and market-based. They're both speech and a commodity. Similarly for copyright, when we look at fair use, again, we're dealing with this question about when can a copyright owner use the law, use the state, to prevent other people from speaking. And when can that subsidiary speaker, the second speaker, so to speak, have the right under fair use. So again, we're thinking again about the structure both of exchange of information and ideas as well as the exchange of commodities when we talk about copyright. The area of standard setting and the issue that arises, specifically within the Indian context with mobile phones and Ericsson, may seem like a strange example, but the whole idea of standard setting is a matter of open science, is what I'll argue. It's really a way in which industry can create certain types of standards for commodities. And those standards are based upon science. And so to what extent then can you have a system, when you're thinking about the standard setting debate, where one entity through patent law can control the standard, can control that flow of that particular scientific knowledge or scientific principle? So even though standard setting might seem a little bit a strange example, I think it would be an interesting example to end with, to explore some of these ideas. But to make sure that we have a sort of a common language to understand this notion of freedom of speech and freedom of markets, let me give you a sense of the legal landscape. Now, this is again something as a comparativist that will obviously vary from country to country and within a country from time to time. From historical period to historical period. So I'm trying to give you a fairly broad kind of structure, broad set of principles regarding freedom of speech and freedom of markets and see how they fit together. And then with that in mind, we'll get into the 3 examples that I mentioned, trademarks, copyright, and then standard setting. And so the first notion of free speech has to do with the idea of censorship. What exactly do we mean by censorship? When exactly is the state censoring someone? At a very coarse level, it may just simply mean the state is not allowing you to speak. But there are lots of ways in which the state does not allow us to speak. The standard cliche is we can't shout fire in a crowded theater. We can't make false statements. We know that falsity is something that the state can prevent. And if your statement is false, then the state can come in and regulate that and control that. There is a very interesting case in the US. I love talking about this case regarding censorship, which is the United States versus Alvarez case. So the United States gives out medals, much like the Indian government does. I think one medal it gives is the Congressional Medal of Honor. And apparently it's a crime, or it used to be a crime, to say that you falsely have been given the Congressional Medal of Honor. So if I tell you, Professor Scary was overly generous about the introduction, but if I had said right now, in addition to being a law professor, I'm also a Congressional Medal of Honor recipient, not true, I may have broken the law, and to the extent that they could reach me over here on the other side of the planet. So this is a very interesting case because Mr. Alvarez was criminally penalized under this law because he was a politician in California, and as politicians are often accustomed to do in many places, exaggerated a little bit about his credentials. At this time saying he had won the Congressional Medal of Honor. And so Mr. Alvarez challenged the law, challenged his conviction all the way to the U.S. Supreme Court, the United States Supreme Court, basically saying that this law violated his rights of free speech. And the initial impulse to this type of this type of challenge might be, well, false statements are not protected, right? If somebody commits fraud, then that's not protected by the First Amendment. If I engage in securities manipulation or other types of things, that's not protected by the First Amendment. We accept that's something that just the government can censor, so to speak. But the Supreme Court here found in favor of Mr. Alvarez. And in a very interesting way, they basically said, well, this was a falsehood, but it wasn't a falsehood that really rose to fraud. And the interesting language in this case suggests that even false statements can be protected under the First Amendment, which is really kind of a puzzle. What exactly is it about false statements that would ever make them protected? This was not just simply a case on procedure. The court could have said that this is just a de minimis. I mean, many people may make silly statements like this, and the law is not going to go after them. The court did not just simply say that. It didn't say that the law was vague. It didn't say there was some procedural problem. It actually went out to say that sometimes false statements might be protected. So this is quite a bit of a quandary. And one of the ways to resolve this is that the court is really focusing on falsities that harm people, that there's some implicit notion of harm that gives the basis to censorship. And if there's no harm, no foul, I mean, if, as I suggested earlier, the electorate is used to hearing politicians making grandiose statements, so they may not even have been listening when he made this statement. So it did not affect their decision. Certainly there was no evidence that, he won elections simply because he lied about his winning this particular medal. I think this goes beyond the notion of just simply no harm, though. Because I think what the court is recognizing is that in an exchange, false statements might be made. They might be made either to puff up your situation, they might be used rhetorically, they might be used when we don't know. So, whether a statement is false or not. I mean, this is sort of an interesting criminal law issue about the mens rea required for this. But, there was some sort of an intent or purpose, but the court may be working with different shades of knowledge or grades of knowledge in terms of when they're looking at this statute. But when you think about the whole idea of exchange between two individuals, people might be, arguing about anything. They might be arguing some sort of scientific principle. How does your iPhone work or your smartphone work? Now, if you're a scientific person, if you're an electrical engineer or a communications person or a computer science person, you might understand that detail. But maybe you just simply learned enough physics to get by your matriculation exam, then you think you know everything. And so you have an exchange with your friend who also thinks he knows everything. And so you say, oh yes, this must be how it works. Clearly you're just, I won't use the bad language, you're just going back and forth in this particular way, exchanging falsities. So is that somehow valuable to the exchange of ideas, to the marketplace of ideas to exchange? I think the answer is yes. You think about, for example, scientific progress. Science often involves people going back and forth, exchanging things that may be completely wrong. And the whole idea behind obtaining progress in that exchange is at some point recognizing you're wrong. But the right to be wrong, the right to say things that are misstating, that don't harm anybody, is something that the court is recognizing in Alvarez. And so I think that's a kind of an important way to understand this notion of censorship. Now, what we mean by censorship really sort of boils down to two things. And I'll give you some examples of cases. One is that there's no prior restraint. I think people may be familiar with the notion of no prior restraint from Blackstone. This goes back to Blackstone's commentaries, where he talks about notions of freedom of expression. Prior restraint, basically the government can keep you from talking before you ever talk, right? And so can the government keep a book from ever being published? The general answer is no, maybe only in rare situations. So you do have some interesting cases where the book might involve national security. or the book might disclose some government information or some government secrets. In that case, the government does have the right to review the book and make sure that none of those secrets are disclosed and so forth. That can be an example of a type of prior restraint that is allowed, but in general, no prior restraint. Again, the view is if you do make some sort of speech that is harmful or that might be otherwise troubling, then instead of the government keep you from speaking, the government should just let you speak, let other people respond, and if there is some sort of harm because of fraud or something else, then some damage can be paid. What economists call liability rules can resolve the issue rather than keep you from speaking at all. So that's one important notion to keep in mind by censorship, no prior restraint. And if the government is engaging in an improper prior restraint, and what I mean by that is not justified by the government protecting some sort of security or other interest, then that prior restraint would be a form of censorship. The other type of censorship that's interesting is the government cannot force you to speak. The government cannot force you to take a pledge that might violate your conscience. The government may not force you to speak in a way that would be in contradiction to what your political beliefs are. The government cannot force you to speak in a way that keeps you from developing your own political beliefs. So there's some very interesting cases. One of the famous cases involves the Pledge of Allegiance to the flag. Can a state university or state college force the students to engage in the Pledge of Allegiance to the flag? I've spoken the Pledge of Allegiance, but not recently. I speak it in my heart, even if not my tongue. But in any case, I don't remember the words to the Pledge of Allegiance. Something like I pledge allegiance to the flag for which it stands, one nation, under God, so forth. And so part of the Pledge of Allegiance, I forget when it exactly was authored in the U.S., sometime in the early 20th century, I believe. And then it became part of this kind of national culture for a little bit. Part of the Pledge of Allegiance does include the phrase, under God. And so the challenge under the First Amendment is that, what if you don't believe in God, or you don't believe in taking oaths? Can the government force you to say the words under God? And so the Supreme Court basically said no. That would be an example of forced speech, and therefore that would be a type of censorship, not in the sense that you're prevented from speaking, but more that you're asked to take on a position that you may not actually believe. And so you get into some very interesting issues with this that I'll be glad to take in questions and answer that with loyalty oaths. Some universities still do have loyalty oaths that you're not going to be members of particular types of parties, you're going to not advocate the overthrow of government. That type of speech, those types of statements, the universities still do try to regulate and raises some interesting questions that I'll be glad to address under this notion of no forced speech. But nonetheless, that is kind of a standard principle, a big principle. Just to give you a sense about how, one way to gauge how strong a principle it is the trivial circumstances in which it gets enforced. And so one of the famous cases involving this in the US from the late 1970s involves a license plate, the license plate that you have on your automobile. And each state has a different license plate, just like here, but the license plates in the US are more elaborate. They're basically used as advertising by the state. And so you go to New York, it has pictures of Niagara Falls and the Empire State Building, the Statue of Liberty. You go to California, it has pictures of the Golden Gate Bridge, Hollywood, all these types of things. They're advertising by the states. No space in the United States will go uncovered from advertising, including license plates. And so that might be true in other countries as well, increasingly. But in any case, in this license plate case, the state of New Hampshire had on their license plate the phrase, "Live free or die." And the particular person, Woolley in this particular case, said, "I don't want to have this phrase on my license plate," for whatever reason. I don't remember particularly what the objection was. It wasn't you could argue that ideologically it's different than saying under God, which you may or may not believe in, or you may have some different beliefs in. Just didn't like the phrase, I guess. It is kind of a harsh phrase, live free or die, strongly libertarian. And the Supreme Court said, no, the state, by having that on the license plate, was sort of forcing speech. Again, this is sort of a metric of how seriously a principle is, maybe about how trivially it gets enforced. Having that on the plate, forced speech, and so in many states, in most states, you have different alternatives for license plates and so forth and so on. So this is one set of principles about censorship that I think is important to keep in mind, especially when you get into intellectual property. If you're thinking about, for example, of a copyright owner preventing somebody from publishing a movie based upon the book. So somebody might have a web page, to take another example, or a YouTube video based upon Harry Potter. To what extent is that censorship if the copyright owner uses the law to prevent that from being published? Well, it really depends on whether you're viewing that as a prior restraint or some type of forced speech. And this is what makes the copyright cases so complicated. On the one hand, okay, you could have the Harry Potter video made and produced on YouTube, but the maker of that video might still be liable in damages. No prior restraint. Alternatively, copyright owner often argues, well, I don't like the particular way in which they have made the Harry Potter movie on YouTube. It may have some political implications I don't like. It might have some even artistic implications I don't like. And therefore, I'm being forced to speak as the copyright owner because people will see this and think. And so this becomes, a difficult tension within copyright law that we'll talk about in a few minutes. Okay, so we've talked about censorship and kind of parameters around censorship, and there are lots of cases that try to see how you work through those parameters, both in the US and in other countries. The next set of cases or next set of principles that are worth talking about are the attempts to regulate speech. So the idea is that you're not kept from speaking, it's more that there's some restrictions or rules, either on how you speak, or where you can speak, or the manner or nature of the speech you can engage in. Some of these I won't talk so much about, but things like licensing. So if you need to get a license or a permit to do a demonstration or to do some sort of a public, those things generally the court will say that's not a violation of First Amendment as long as that license or permit is provided in some sort of a neutral way, so that there's no discrimination. It's not cheaper for Democrats to get this than Republicans, or cheaper for Republicans to get this to use those parties from the US, as long as that's done neutrally. Where it gets very complicated or more intricate, are three areas. I think I won't talk about them in much detail, but I just want to lay them out. One is campaign finance. Can the government regulate how much you spend on campaigns? And specifically, can they regulate how much you give to a particular politician? And generally the view about that is the government can regulate how much you give to a particular politician. And so this is something that is part of, a big debate in the US. There's a couple of cases in the US Supreme Court now about what constitutes corruption. And there's been a lot of criticism about this because the notion of corruption with the US Supreme Court is very narrow. It basically boils down to some sort of quid pro quo, some sort of express bribery. But what if you just simply have a lot of money and you're just simply, spending your money in a way that gives one politician an advantage over another politician? Can the government use the law to somehow even the amount of money different parties spend so that it's more equitable? The answer to that is no. Basically, even if there is that type of corruption of the system, as some people say, that's speech. So that if I want to set up a particular fund, or if I want to make a movie that's in favor of, name whomever the campaign you advocate for, then the government cannot control the amount of money you spend on those types of things. That's not viewed as a direct bribe or a payment to a politician, even though, as the argument is often made, if I spend a lot of money, let's say, on candidate Trump's campaign, one of the reasons I want to do that is because I know candidate Trump will give me some benefits, most likely. Maybe not directly, but indirectly. But that type of corruption is tolerated. If you want to call it corruption, is of course debatable, but that's kind of the view that you can't level the playing field. And again, this is a notion, again, of really going back to freedom of speech and free markets, that it's not about distribution. You know, this is kind of the classic liberal, laissez-faire, free market notion. Distributional questions can be handled maybe in other ways, and maybe they can be handled, this is where it gets very touchy how you do that with campaign finance, but maybe through general policies that try to alleviate poverty or try to equalize access to resources. But the state can't directly redistribute from one campaign donor to another by basically saying, you can only donate so much. Or to put it more bluntly, you can only donate as much as the least affordable person can donate, right? That type of cap, those types of restrictions or distribution would not be favored. The other area where you get some very interesting cases have to do with regulation of advertising. And many cases about this, especially with attorney advertising and the profession. It's a very interesting interaction between free speech and free markets. And so attorney advertising was strictly forbidden, really restricted by the states up until the 1970s. And the big argument that arose against those restrictions was that, you know, if you didn't have advertising, how would people who cannot afford a lawyer find a lawyer? So that if you didn't have advertising, then the way you'd find a lawyer is you'd go to whoever used a lawyer in the past, and typically the way in which this would work, there would typically be somebody who's well-heeled. Maybe your corporate friend or your business colleague will know which lawyers to go to. But if you're the ordinary person on the street who is in need of a lawyer for a divorce or for a will or for something criminal, whatever it might be, you may be more difficult in finding a lawyer. Advertising will make that more possible if lawyers could do that. And so this argument, there are several cases in which then the courts basically moved to say that the First Amendment protects attorney advertising. It doesn't make it an absolute, but you do see some very strange advertisements in the US. You just simply have to go to YouTube and you probably could find them. I haven't seen as many here, but I get the inkling that attorney advertising is going to become very big in India in the next 10 years, and we can discuss that in what ways. But don't go the way of the US. The only benefit I can really see from the liberalization of attorney advertising is there's a wonderful show called Better Call Saul, which may be playing in the US, which I recommend. That's all about attorney advertising. And it's a wonderful show about attorneys nonetheless. But I'm not sure about whether attorney advertising has led to the benefits that you know, people counter. The big issue now is, okay, we have generally say that attorney advertising is protected by the First Amendment. How far can that go? Can an attorney then just go to somebody's funeral and say, oh, I'm very sorry, here's my card? Can attorney go to a hospital and say, I'm very sorry, here's my card? Attorneys have a very nice way of saying that, I'll just say it more glibly. Or can you show an advertisement that basically says, if you hire me, and then a rain of dollars comes from the sky? Can you have a phone number? So, you know, you have very strange phone numbers in the US. So for lawyers, you might get something like 1-800-KA-CHING. What is ka-ching? Ka-ching is the sound of a cash register, you know, when you're opening. Can you do that for a phone? Is that somehow misleading? So many of the recent attorney advertising cases are now saying, okay, we recognize this under the First Amendment, but we also recognize that this can go too far. What types of regulations do you allow? So it gets a very interesting sort of area about regulating speech. The one last area that I want to talk about before getting to my 3 examples has to do with a very interesting case from 2011, which has to do with access to data. And this is kind of a complicated case factually, but it's a nice segue to think about both the relationship between speech and markets, but also to think about intellectual property and information and knowledge. And the particular issue had to do with pharmaceutical companies getting data from pharmacists. So the way in which typically prescriptions are filled. If you see a doctor, the doctor says you should take this medicine, you take the script or the prescription to the pharmacy fills this. The pharmacy, especially in this day and age, is now creating a database. And the database is creating information about what types of pills are being prescribed, some demographic information. There is a federal law called HIPAA in the US that would protect the identity of the patient, but other information that is non-patient identifying can be collected. And more importantly, from the perspective of pharmacies, can be sold. So many states made a restriction that this data from pharmacies could not be sold to anybody who either works with a pharmaceutical company or collects this data for the purposes of selling it to a pharmaceutical company. And so what pharmaceutical companies were doing were collecting this data. They couldn't identify the patients, but they could identify the doctors. And so they could say, this doctor has been prescribing this drug. Well, this drug is from my competitor. Maybe I should contact this doctor and say, oh, you should try this other drug. And it's a little bit disturbing. I've had fairly good, I mean, the doctors I've dealt with are fairly good in the US. I don't want to give a negative impression. But there are situations when I visit a doctor or visit a new doctor, and even before I see the doctor's receptionist, there's a representative from the pharmaceutical company sitting in the doctor's office, largely because they're talking to the doctor to get the doctor to prescribe certain things. And there are certain doctors whom I've formerly seen who basically said, well, okay, you're in good health, but do you like to try this pharmaceutical? And my initial implication is I really don't try pharmaceuticals recreationally, and I don't feel that sick. But certainly there is that marketing that occurs. And there are lots of ethical rules about this, especially doctors who've lost their license, because once they start this relationship with the pharmaceutical company, they somehow suddenly get bigger houses and nice swimming pools and nicer cars and so forth, and that's obviously a problem. So many states basically passed those laws that restricted the sale from pharmacies to individuals. The people who would buy this data would not be the pharmaceutical companies directly. There'd be go-betweens, typically, intermediaries, jobbers, or runners, sometimes they're referred to, who basically would aggregate this data, create their own database, and then sell them to pharmaceutical companies. But the statute was written as a way to try to limit those transfers to pharmaceutical companies. Supreme Court, in that case, 5-4, IMS Sorrell basically said that those statutes violated the First Amendment rights of many parties. First Amendment rights of doctors, the First Amendment rights of the pharmaceutical companies that were at issue in this particular case. IMS versus Sorrell is one of these cases that was, I think because it was so factually complex and not, pharmaceutical data, pharmacies, doctors. I mean, it all sounds interesting. But there's no murder in it. I mean, how are people going to be interested in that, right? There's nothing really, something that's going to be on the news. But it's a very important case for First Amendment and regulation of information. And the reason why the court said that there was a violation of the First Amendment in that particular case, a number of reasons. One is that there was this basic notion of access to data or information. And that the court was really concerned about if you allow, and so this is a very common argument, the court may not be so much concerned about this case, but what comes after. And so if you allow the state to not allow access, to prevent access to this information, would that prevent the state, would that allow the state to prevent access to other types of information down the road? The other aspect of this case that's interesting is the statute itself had some exceptions. And so this is kind of an interesting point as a practitioner, as a constitutional law thinker, whatever role you find yourself in, that especially if you've got a statute that starts off with some very general concerns, such as the selling of this data, but then creates a set of exceptions so that it seems like the law only applies to maybe one or two individuals. That does create some constitutional concerns, certainly under the US Constitution. It may raise some questions about equal application of the law. it may raise some concerns about whether the government is drawing a restriction based upon certain viewpoints. And specifically the restriction, the exceptions included something like researchers, universities could buy this data. And researchers and universities do buy this data. There may be researchers in the field of public health that would be very interested to look at this pattern of how drugs are prescribed. There may be researchers in business schools, researchers in law schools that might be quite interested in how excuse me, this information is used. That was an exception. And so the court started wondering, well, you know, if that's an exception, why isn't that equally problematic in some ways that this data is out there? Couldn't this data then eventually also make it to pharmaceutical companies, especially when you have this collaboration between researchers and pharmaceuticals? Where exactly, you know, does this distinction come from? Is it viable? So you have the majority in that case of really finding a First Amendment violation in a law that seemed to be controlling the access to information, but information that seemed to be commercial in nature. In other words, the buying and selling of pharmaceuticals. And that's the point that's very interesting about that case. Because prior to that case, the court often thought about commercial speech as something that had a whole different kind of rhetoric or a different set of rules associated with it. Think about the attorney advertising cases. Those are commercial speech cases. And even though the court recognized that there is a First Amendment protection or free speech protection, it also recognized that consumers have to be protected. And therefore there could be some role for regulating advertising. That seemed to be thrown out the window in this particular case, because the court really didn't think about, well, does this affect the patient-physician relationship? If this use of the data about prescriptions facilitate pharmaceutical companies in targeting doctors, and therefore indirectly targeting patients for particular drugs. There were 4 judges in dissent in that case, which basically emphasized that point and really talked about the commercial nature of this transaction that should temper any free speech concerns that arise. And this is kind of an important point when we get into the trademark issue, which I'll finally get to in 1 minute. So just to sum up this section, right? I've sort of given you an idea about how freedom of speech and the principles that govern it. I've also told you that this becomes an interesting issue when you're talking about regulating speech rather than censoring speech. It also becomes very interesting when you're thinking about speech in the context of economic regulation more broadly, as you see in the pharmaceutical case. The general view in the US regarding economic regulation is that Congress can do what it wants. The Parliament can do what it wants as far as economic regulation, unless the economic regulation violates some sort of civil liberty, such as the right not to be discriminated against based upon race or gender or religion, or actually sexual orientation isn't on the list yet, but it's hopefully getting there. Then the economic regulation, passes muster under the Constitution. Some of that, was brought into sort of a gray area with Obama's health care. As you know, as you may have followed, this is still going on, and there's some very interesting, sort of subtle changes in the law regarding economic regulation. I mean, my view is that under the law as it existed in 2010, it's just economic regulation. It meets the requirements of due process. No problem, just very low-level review. But now you're getting challenges, one challenge that was successful to a certain extent in terms of how it affects the state's rights in terms of taxation. Now you're getting lots of challenges based upon religious liberties. If the idea is the employer has to provide insurance to the employee, what if the employer has some religious objection to a medical procedure, such as abortion or some sort of access to medical devices such as contraceptives? How should that affect them? So that's still being Supreme Court ruled on it loosely last week by basically sending the matter back to the lower courts. in a decision, but it's still going on, which suggests the ways in which speech and markets somehow, or expression in markets intersect. So let me end. I started, I think, a little 10 minutes after, so we'll go a little bit, so I'll leave time for questions, with how intellectual property mediates all of this and how these issues really come up in those areas. Hopefully you've got a sense of sort of this framework and then the specifics. The trademarks cases are very interesting. I noticed when I was looking at the Indian Trademark Act that you have restrictions, I think within Section 9, about registering trademarks that might be hurtful based upon religious feelings, religious beliefs, as well as marks that are scandalous and disparaging. The general prohibition that's at issue in the U.S. right now have to do with disparaging or scandalous trademarks. So there isn't a specific provision that deals with religion, but any sort of religious objections might be coming up under the general heading of scandalous or disparaging. There was a ruling by the lower intermediate court about a year ago in a case called In Re Tam that basically said that that provision, that denial of registration, is a violation of free speech. So there's a very thorough opinion, 70 pages, where the judge basically was trying to go through every possible variation on this issue to basically say, no matter how you look at this issue, it's a free speech violation. I won't go through all of the variations on this, of course, but the basic issue that the court focuses on for free speech is the notion of disparaging or scandalous is something that's based upon viewpoint. Who's to decide when something is scandalous or disparaging? So one of the examples they keep giving over and over again in the opinion, it keeps coming up. It's almost as if there's only one example they could find. But it had to do with the denial of registration to a trademark. The trademark was Stop the Islamization of America. And so it was a political organization that had this trademark. The trademark office said that this is disparaging or scandalous, and therefore will deny it. The court said, well, that's just based upon one particular viewpoint. If it had said something positive about the religion or tried to promote the religion, then they would have upheld the trademark. And so the court was very concerned about, the courts in general are very concerned about the government making this kind of viewpoint discrimination. Now, I think in the context of trademark, this goes a little bit too far. Of course, we don't want to say that there's one set of rules for one group or one viewpoint and one set of rules for another viewpoint. But if you think about what the court is saying, that something is disparaging or something is scandalous is based upon pure viewpoint, people may be familiar with this notion in trademark law of tarnishment or blurring. It comes up under this doctrine of trademark dilution. Well, trademark dilution is a situation where a trademark is being used in a disparaging way. So just to give you an example of how this comes up, and again, the seriousness of the law is indicated often by the banality of the case. So this is a case involving, I think it was Gucci, was it Gucci? I forget exactly, it was a luxury brand, and basically the brand, I'm trying to remember what the disparaging trademark was right off, I don't remember what it is right off.
Chanel and dogs.
Yeah, which one was it, sir?
Chanel and dogs, if I remember.
Yeah, what was it?
So it was something about Chanel makes bags.
Right. Well,
so
yeah.
The case was that someone came up with a mark. It wasn't used in the course of trade. I think.
Right.
But someone came up with a mark which said that, which basically puts a purse, a big purse, and some puppies.
Yeah.
To say that they kill the puppies to make the purse.
Yeah, there's that example. There's also an example where they have the luxury brand, but somebody then creates a competing brand for dogs. And I thought it was Gucci and Poochie, something like that.
Yes.
Yeah, that's right. Louis Vuitton and Chewy Vuitton. Louis Vuitton had the bags. Yeah, Chewy Vuitton had the mock brands. Okay, so this was found to be, but these are all other examples that are very similar in this vein. Was found to be dilutive or disparaging of the trademark Louis Vuitton. And so this again is something that would be viewpoint based, I think, given the logic of the court. And so the cases may be going to the US Supreme Court, and I can talk about it in more detail, But this is a situation where the court really was taking this notion of viewpoint neutrality and kind of the freedom of the marketplace without really understanding the context in which this was being used. And so to really understand, I think, that case, especially trademarks, and I think the court completely misses the point, is that trademark itself is a form of regulation. So that the trademark law is not setting forth some sort of free market. It's basically saying that if you want to use brands and bring them into the marketplace, you have to follow these particular regulations. So if the government then is imposing these regulations, and we all agree, or at least nobody is challenging trademark law on its face as being unconstitutional, then we have to ask whether within that regulatory framework, having some restrictions for disparaging and scandalous marks makes sense or goes beyond the line. And I think it can be justified, and I'll be glad to go into that within the trademark regulatory scheme. Two quick examples again about copyright and fair use. I mentioned this issue in copyright about when the copyright owner prevents somebody from speaking. How should that be handled under fair use, under First Amendment, free expression principles? I generally view that fair use in the U.S. can do it pretty well. There's been a lot of criticism about fair use, largely on this notion about whether the judges are acting in an arbitrary or predictable way. But I think in many ways, fair use has worked out the right way. In the context of parody, I think the courts have come up with some very good results protecting parodists or satirists. Again, there's a big distinction, big argument about what that might arise. But in general, when you think about protection of or generation of free speech issues, fair use has been sort of very, very powerful and very helpful in that regard. Let me just give the third example, and that is the one regarding standard setting. The standard setting example is a situation where you have industry players coming together to create some sort of standard for a product. In the dispute that's happening with respect to Ericsson, the standard has to do with smartphones, and the question then is whether Ericsson is violating competition law in enforcing patents that surround this particular standard. And I've written about this and talked about this, and many of you are familiar with this issue, may have seen this issue from the perspective of competition law. To what extent is the enforcement of the patent then creating an anti-competitive situation in the market for cell phones? I think it's also useful to think about it from the perspective of freedom of expression. That when you're thinking about a standard, you're talking about some set of scientific principles, and these types of scientific principles. It may not be pure science. It may be science in the most applied commercial sense that you can imagine, i.e. selling a product. But nonetheless, the same principles of open science should be brought to bear on this particular issue to think about how access could arise. And I'll be glad to take any questions on this. So I want to just end with three thoughts, and hopefully the paper, the discussion somewhat coheres. At least we were able to pass an hour together without too much discomfort and hopefully some exchange. But the three thoughts basically are that when we think about freedom, that you also need to think about the context in which the freedom is exercised. That freedom is somehow not acontextual, it doesn't somehow just exist in the air. And one of the dark aspects of that is that freedom really depends upon some notion of social order. And we need to think about what that social order is. The problem is that often in trying to defend one's freedom, and you see this in the area of national security, you may be even seeing this now in the area of immigration in the US, and might explain some of the presidential statements that are somewhat non-presidential that are being made, that the quest for order, right, sometimes might supplant the quest for freedom, that one might come over the other. But I think our job as lawyers and legal academics broadly, as thinking people, is to really think about how we design these institutions so that freedom does flourish within the right set of social contexts and institutions. And so I'll just leave you with those thoughts, and thank you for your time. I'll be glad to take any questions.
In light of your... Can you use the microphone?
Yeah.
In light of the increasing freeing of commercial speech in the United States,
Yeah.
I was interested about the sort of critique that exists about political correctness in the American context and
Yeah.
gentrification, right? And how it talks about in this something the only thing that can live in such a world is advertisements. So
Yeah.
your take on that?
Yeah. Well, there's lots of there. I don't like the phrase. I don't know what the phrase political. I've never understood what the phrase political correctness means. There are always rules for speech. Political correctness, I think, is often used in a very kind of a disparaging way rather than in kind of an affirming way, or even in a meaningful way, in my opinion. But I'll be glad to kind of elaborate on that if there are any further questions. I think the latter point is an interesting one because of the, what do we mean by advertisements in commercial speech? One way I could have done this, I was thinking of doing this, I thought this may be too subversive, is to basically say that everything is just advertisements. Everything. My law review articles, this is an advertisement, my exchange with you is an advertisement, that everything is about self-promotion. And to a certain extent that's true, and maybe that is kind of the oil that lubricates all human interaction and exchange. And there may be some value in looking at it that way. The more I think about it though, that I think it has some resonance, I'm just not quite sure as a practical matter how that's useful to start characterizing everything as advertising and promotion. That's at some level, there is such a thing as genuine exchange, where I'm not just trying to promote something, I may actually be trying to state something to you, right? But think about literature. Did Jane Austen write Pride and Prejudice to advertise Pride and Prejudice and zombies? Obviously not. But you could make the argument that every book is just an advertisement for the movie to be made out of that book, and every movie is just advertising the next book, and so forth and so on. And so there is that sort of commercial. But one way the advertising metaphor helps, I think, is that it is about getting attention. It's about audiences. That when we're thinking about this notion of exchange, whether we're thinking about exchange of information or exchange of goods, it is about getting that kind of attention from someone and getting that kind of interaction. And what I mean by that sounds a little bit abstract, but what I'm getting at that is tied into my concept of freedom. Freedom is not just sort of this individual or individualized notion. Freedom only matters in some sort of social context, and we need to think about social context. So if you take a more tempered notion of advertisement as really about getting attention, getting that kind of communication, then maybe that's a bit more moving forward than to think about it all as about self-promotion. Yes?
So I'm just wondering, in the US, are there constitutional standards for when you can restrict the rights under someone's rights under the First Amendment? For instance, in the case that you mentioned on regulation of access to data with the pharma companies. So, for instance, if it can be established that allowing pharma companies to buy this data results in patients being prejudiced because doctors prescribe drugs which they shouldn't be prescribing, would that right to health or right to life trump First Amendment rights?
Yeah, this is a great question, and a lot of it depends. First of all, there are sort of standards, plural, and they're sort of all over the place in terms of First Amendment. It's probably one of the more contested areas because there's so many different ways in which the analysis can proceed. The way in which often this proceeds is based upon the nature of speech, and so the way you can understand or predict how a case is going to come out is how the court characterizes the speech. So if, for example, they characterize the data, the pharmaceutical data in that case as, as maybe communications between the physician and the patient, or had characterized it as private patient information, it might have had a different result. The way they characterized that speech at issue in this case was very broadly information or data. And once they characterize it that broadly, the court is going to look at this a little bit more carefully to make sure that it doesn't get infringed. So a lot of this depends upon those broad things. One aspect of these standards is, once you have it characterized in a particular way, to what extent will the court look at harmful effects or what the courts talk about as secondary effects? So this comes up in a lot of the case law involving regulation of pornography. And so the US law, basically I think this follows, is that pornography is protected under the First Amendment, but obscenity isn't. So then the question is, where's that line between obscenity and pornography? And this kind of, how you draw that line is related to this question of what the harmful effects would be. So for example, I don't want to get too culturally specific, also too graphic. But let's say, for example, you had an adult club, right? That was in a particular neighborhood. To what extent can the state say this club cannot be here? And so there are a lot of First Amendment issues that arise there to say, well, this is just, on the one hand, it's just pornographic entertainment, therefore it gets some First Amendment protection. If there's some sort of a naked dance going on, it has been the argument to say, well, that's a dance. Forget the naked part, it's a dance. Therefore it's expression, and therefore it gets protected under the First Amendment. And so in these cases, the court does say, well, what if they say, we don't want this club here because then the whole neighborhood, once you allow this club, then more clubs will come, the whole neighborhood then will go down in value, and those secondary effects. And so the court, to a certain extent, does allow states to consider that when they're regulating certain types of speech in the pornography obscenity context. But they may be using that to somehow negotiate this obscenity pornography distinction. But outside that, I think in the pharmaceutical, I think they should. I mean, that was the dissent in IMS, the case I mentioned. We got to consider what the purpose of the regulation, not just simply say it's speech and say, oh, the speech is being infringed. You need to really start with why you need the regulation here. Much like what I suggested for trademarks. Yes. Two more, yeah.
So, my question would be with regard to the campaign finance in America, more specifically the Citizens United judgment. Are we seeing a scenario in the US wherein ideological arguments behind the First Amendment are now ignoring the effects that are there on the ground? Surely, free speech is very important, markets are extremely important, they've delivered economic growth to the world.
Sure.
But in the scenario that we are right now witnessing, are we seeing that the court is getting lost in constitutional debates and not seeing the effects of a judgment like the Citizens United? This becomes especially important because I think last week a court in the US has said that you can directly fund politicians. So a governor in some state is being given Ferraris and whatnot and
right.
things like that. And just to follow up, sir.
That's not going to be. Wait, go ahead.
Okay, this is a question that is slightly unrelated, which is that do you think that so we've seen China and the unnamed country that you were talking about.
I was actually thinking of Singapore, but that's fine. We can talk about China.
I'm sorry, right. So
I don't want to say what other
right, a country which is more authoritarian and has now achieved economic growth. Do you think that a country like India, which now has more democracy, a political democracy at least, can now have a lot of economic?
Yeah, and I think that which questions should I answer? I forget the first one now. The second, the first one was about the ideology. I think ideology is always effective. It's hard to. There's a lot of. We could have a whole separate course about how judges decide and the role of ideology. Clearly, there's ideology there. Maybe there's more of an ideological divide now in terms of how the judges have been selected, but it's always been there. This is nothing new. If you look at, for example, some of the First Amendment cases involving censorship of books, for example, the Ulysses case or the Roth case, these cases involving that, that might seem like, okay, these judges are just, they don't understand, Henry Miller, they don't understand these books. But those are deeply ideological. In those cases, there's a deep split between those who want to be more aesthetically follow literature as their guide versus those who want to follow religion. That's putting it a little bit simplistically, but the arguments for censorship of books largely are based on religious grounds to say, well, local communities can say we don't want to see this on the screen, we don't want to have people have these books, have these thoughts, because as they say, it will lead to dancing or whatever. That is an ideological split. I think your second question, again, you could spend so long time, and so it's always been there. So let's spend a long time talking about that. I think looking at an authoritarian model of development, I don't know if that's fully worked. And I think it's really troubling if that's the view that people are taking, and even in developed countries. I mean, even the debates now that you're seeing, in the U.S. presidential debates are debates about development, right? They're debates about, certain communities in the U.S. that industry has left. What are we going to do? Jobs that are being lost. What are you going to do, right? Those are development questions, I'd argue, and I think you would make the case for. And so I do think we need to think about democratic ways in which development arises and authoritarian solutions. And this is where I think, the phrase rule of law gets misused sometimes, because rule of law sometimes is often construed in authoritarian terms. Well, we need to think about the ways in which rule of law, through certain aspects of IP, through competition law, through constitutional law, tries to promote those types of democratic models.
So my question was related to obscenity, and you touched upon it in one of the previous answers.
Yeah.
So, of course, you spoke about the various manifestations of censorship, and correctly, I mean, obscenity is not even accorded First Amendment protection.
Right.
So I was wondering, how does that affect copyright and trademark?
Yeah, good question.
Precisely because political speech or songs or music is, of course, protected, but obscenity is not. So how does that affect?
That's a good question. So right now, copyright is pretty much laissez-faire. I mean, it just has to be original and fixed, and that's true in most jurisdictions. And so the idea behind this is, yet another notion of the marketplace, and that is the marketplace of expression. And so the notion is that copyright law is about defining a kind of a free, as I use the term free, marketplace for expression, and the government should be very careful in terms of not having the standards too high for what gets copyrighted. So that's why you have all of these kind of strange disputes regarding copyright for small things, copyrights in software, because actually the standard for getting copyright is pretty low, and one of the reasons for that is the government does not want to impede, or at least want to appear to be impeding creativity, and not appear to be impeding this marketplace for expression, for expressive works. Having said that, there are scholars who say that maybe one way to deal with obscenity is just simply not to give copyright protection to obscenity. And this then gets to, kind of what combinations of regulation do you want in the marketplace? So it's very similar to the argument like, well, maybe you shouldn't give patents to pharmaceuticals. You're familiar with that debate. The way in which that debate goes now is, well, let's allow patents on pharmaceuticals, but if we think they're being abused, then we'll have other regulations that deal with this. So this is the same thing with copyright and obscenity, even copyright and pornography. The argument has been made that even if pornography is protected by the First Amendment, in order to prevent it because of some of the harmful effects that arise from pornography, especially to the participants, to the ones who are making the pornography, right, the ones who are being filmed, then copyright should be denied to pornography. Again, to try to keep that marketplace from arising. And again, the strands of the debate is, well, maybe it makes more sense to allow copyright, but to have other types of restrictions. So those are generally the parameters. Yes.
So you had indicated that as regards copyrights, that fair
Yes.
use is working satisfactorily.
Yes.
So my question is, given the very given the anachronism in terms of the duration of copyrights, can fair use even be termed to be in any way effective, given the anachronism of copyright, and especially in today's digital marketplace? Effectively, isn't the network of ideas effectively curtailed by the extended duration of copyright?
Okay, and so when you say anachronism, which aspect of the anachronism you mean is the duration?
The duration.
Yeah, because there's another aspect of anachronism that's worth just mentioning briefly, is that maybe copyright itself is meaningless in this day and age, right? That copyright was nice when you had the printing press. If I can just create a digital work that's hard to copy, why do I even need copyright law? So that's another aspect. And so fair use in digital works is why I want to mention that. Is a very, I think, really needed. It's really kind of an area that has to be explored in more detail, because there's a tendency to think about digital works as being outside some of the usual parameters of fair use in practice. Maybe not in the law, and the law does talk about fair use for digital works, but it doesn't work out that way. As far as duration, I think a number of scholars have made the argument that fair use is even more necessary because of the duration. And so some people have argued that as the time increases, so Justin Hughes and Joseph Liu are two scholars who made this point a number of years ago, that as over time, fair use should become more expansive. So maybe once the work is first created, fair use is narrow, but then maybe every 5 years, whatever the time frame would be, that fair use becomes more liberal to sort of counter the fact of the duration. So that would be one way to sort of work.
Thank you so much, Shubha. I'm sure
Okay.
there are many more people
Sorry,
who
went
have
over
many
time.
questions, but I think we need to close the session now because there is, as I mentioned earlier, I think General Circle is organizing another talk which I think was scheduled to start at 6, and I had also promised some of you that we will be ending the session by 6. So thank you once again on behalf of CITC as well as National.